Ada lagi seorang, Tuan.
Okay. So macam mana? Nak mula ataupun tunggu?
Tunggu sekejap.
Tunggu sekejap ya. Okay.
Tuan, salah seorang daripada ahli kami tengah ada masalah internet, jadi perlukan beberapa minit.
Dia presenter yang nombor berapa giliran dia?
Nombor 5.
Okey, tak apa. Jadi kita proceed dahulu yang pertama sampai yang keempat. Mana tahu kita doakan nanti giliran dia dah okey. Kalau giliran dia tak okey juga kita proceed je terus ya.
Terima kasih Tuan.
Apa nama dia? Ahmad Hazim ke?
Farah Nabila.
Oh, Farah Nabila. Okey. Tak apa. Proceed.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi taala wabarakatuh. So we from group 3. Our question is that Nelly is a 27-year-old customer relations officer, and she is a very sexy, beautiful, and passionate lady. She works as a customer relations officer at a famous VIP club in Kuala Lumpur, known as the Men's Club, to support her parents in Indonesia, who are very poor. Nelly is also one of the most well-known customer relations officer among the VIPs in the country. Halim and Ah Chong are two best friends. On Wednesday, around 10 p.m., they both had a drink together with Nelly at the nightclub. The three of them then entered a hotel known as Hilton in Kuala Lumpur around 1 a.m. The hotel is complete with security features such as security guards and CCTV. The next day around 9 a.m., Nelly was shocked by her naked condition without any clothes, and she felt pain in her genitals as well as the presence of semen that was still sticky in and around her genitals. Nelly found Halim and Ah Chong also naked but still sleeping on the living room. Nelly suspects that she was raped either by the two of them or one of them when she was drunk. Nelly had lodged a police report and said she had been raped by two of them without her own consent. The prosecution has further charged Halim and Ah Chong under Section 375 of the Penal Code, and if convicted, they will both be sentenced under Section 376 of the Penal Code. The questions is that, first, what are the evidences to support prosecution case against Halim and Ah Chong? Second, do you think prosecution can prove prima facie case against Halim and Ah Chong? And lastly, what are the defenses that can be raised by Halim and Ah Chong? So, my name is Abdul Nazim bin Abdul Aziz, metric number 1181858. I'll be presenting the first part of the first question, which is what are the evidences to support prosecution case against Halim and Ah Chong? So, in the first question, we have identified three evidence that can be used to support the prosecution case, which is firstly the CCTV footage, secondly the witness, And lastly, the medical evidence. Okay, next slide. Okay, so firstly about the CCTV footage. The issue is whether CCTV footage can be considered as documentary evidence admissible in court. According to Section 3 of Evidence Act 1950, document is defined as any matter embodied in tape, film, or other device. And computer is defined as any device used for recording, storing, processing, or producing any information. We may refer to the case of Ahmad Najib bin Aris against public prosecutor, where in this case it was stated that the CCTV footage is a document produced by computer, as what have been mentioned under the definition of computer and document under Section 3 of Evidence Act 1950. Next slide. Okay, so we will proceed to how to prove documentary evidence, which is in our case the CCTV footage. Firstly, according to Section 62 of Evidence Act 1950, the document itself need to be brought upon the court in order to prove a document as a primary evidence. Whereas in explanation 3 of Section 62, a computer produced document is to be said as primary evidence. So in this case, we can say that the CCTV footage is a primary evidence. However, in Section 1990A of Evidence Act 1950, it was said that the document produced by the computer must be in the course of its ordinary use by tendering to the court a certificate signed by a person who is responsible for the management of the operation of that computer, or by oral evidence made by the said person affirming the operability of the computer. The person who can tender the certificate may be the experts such as from the computer company, from the CCTV company itself, or the guard guarding the CCTV room in the hotel. Next. In the case of KPM, Khidmat Senjan Berhad against Tay Kim Sui, it was said that a document generated by computer, which is in compliance with Section 90A of Evidence Act, is primary evidence. And the next case, in the public prosecutor against Azilah bin Hadri and another, it was said that if the document, which is the CCTV, cannot be proven by Section 90A, it still can be proven by way of calling the maker of the document. Okay, next. So in our current situation, in order for the prosecution to prove the credibility of the CCTV footage, they must first bring the document itself to the court as in accordance with Section 62 of Evidence Act 1950. Then, under Section 90A of Evidence Act 1950, it must be proven that the computer used for generating such documents is in its ordinary course. They will need to provide certificate from person who is responsible for the management of computer, or the person itself can certify it orally. Provided that Section 90A cannot be complied, the prosecution will then need to call the maker of such document to tender the CCTV footage as evidence. Next, we'll proceed with Ainin Sophia for our second part of the first question.
Okay, thank you, Nazim. Before that, my name is Ainin Sophia, and am I audible?
Okay.
Okay, thank you. So for the second issue is whether the security guard can be one of the eyewitness in this case. So by referring to Section 118 of the Evidence Act 1950, it mentions that all persons shall be competent to testify unless the court considers that they are prevented from doing so. And in order for the court to prove the competency of the witness, the court will conduct preliminary examination of the witness. If he able to understand the question put to him and is capable of giving rational answer to the question posed. So next. So by referring to the case of public prosecutor and Nasar bin Ahmad and others, 1986. So by referring to this case, in this case, the prosecution team tendered two witnesses, whereby during the rape occurred, they were both at Gerai as a witnesses, and both of them were telling what they saw, and both of them were merely watching without encouragement or help, and it does not make them as into a accomplice. So in this case, the court held that both of them were not accomplice and that their evidence is accepted. Okay, next. So for the application, we can say that from this case, the security guard is competent witnesses as the facts of the case were silent on the inability or incapacity of the security guard itself. So furthermore, the security guard is usually the one who monitor the CCTV. And for that reason, the security guard is responsible for the management of the computer under Section 19A of Evidence Act 1950. So, although he is just a watcher, his statement of witness may be accepted as he was there during the incident, and the guard can also saw who comes in and comes out from the room of the hotel. So
Sophia, can we refer back to the slide before this slide before application? I think the case law. Okay, PP against Nasar ni. Do you know the fact of this case?
I have read the case.
Okay.
And it mentioned that
The two
during
witness.
The case happened at the by the beach.
Okay. Okay.
They were out.
You understand about this case, kan? PP against Nasar.
Yes.
Okay. What is the difference between Nasar's case and our recent case? With
From the
regard
fact
to
of
the witness.
from this case, the difference is during the outside the building, because of the crime happened outside by the beach. If I'm as far as I've concerned.
I think not really accurate, yeah. Okay, basically this case is totally different with our case, yeah. Nasar bin Ahmad case, if I'm not mistaken, the witness saw the incident, meaning to say they see what happened to the victims between the OKT and the victim. They see by their own eyes. Whereas in our recent case, the security guard working in the hotel, not inside the room. So that is the main difference. Never mind, you can proceed with your presentation. I just want to know whether you understand the facts of the case.
Yeah, thank you, sir.
Okay.
Okay, next. Okay, next. So for the next issue is whether the specimen found in and around Nelly's genitals are from Halim and Achong or one of them, and thus this specimen can be tendered as evidence in court. So we can refer to the expert evidence in Section 45 of Evidence Act 1950, whereby when the court has to form an opinion upon a point of foreign law or science, the opinion upon that point of person specially skilled in that foreign law, science, or art, or in question as to identity or genuineness of handwriting or finger impression are relevant facts, and such person are called expert witness. So next. So by referring to the case of Syed Abu Tahir, anak lelaki Muhammad Ismail, and public prosecutor, in this case, the acts of sexual intercourse were sufficiently corroborated by the two doctors who examined the girl and the accused respectively. So in other words, medical evidence is sufficient to corroborate the girl on the act of sexual intercourse. So we can see that from this case, the expert evidence given by the prosecution is the two doctors. So next. So and also we can refer to the case of Muhammad Zakwan bin Zainuddin and public prosecutor and others appeals. So by referring to this case, the medical evidence proffered by experts who are pediatrician and obstetrics gynecology expert, supported by medical report and the description of tear, is to be regarded as strong, independent, and corroborative evidence of the sexual abuse which had befallen the victim. And in this case, the court found that the appellants or the accused guilty and dismissed the appeal made by the accused. So next. So for the application, in order to prove the possession of the specimen, it can be corroborated by way of medical and expert evidence. So the medical report must be tendered in court and supported with expert evidence, which is by a doctor or a chemist. So if it proves that the specimen is belong to one of them through DNA, that person shall be convicted. Okay, that's all from me, and I shall pass the floor to the next person.
Okay, thank you, Sophia.
Welcome.
Bismillahirrahmanirrahim. Am I audible?
Yes.
Okay. So continue with question number 2. So the question is, do you think the prosecution can prove prima facie case against Halim and Achong? So, okay, so what is prima facie? Prima facie case is a case made out by sufficient testimony, one which is established by sufficient evidence and can be overthrown only by rebutting evidence accused on the other side. So once the prosecution is successful in establishing the prima facie, then it may be rebutted by the accused with a strong evidence. A prima facie case is proven when the prosecution has produced evidence to prove every ingredient of the offense, which if the defendant failed to explain, will result in he or she being found guilty. So when the accused failed to rebut the evidence provided, then the accused can be found guilty in this matter. So in order to prove beyond reasonable doubt in criminal case, the prosecutor has to prove the prima facie case, and if this is, then they have
Nadira. Nadira. What happened to Nadira? Nadira behind you, Sophia.
Yes, Tuan.
Ask her to use your computer.
Sorry.
Okay.
Yes.
So, I'm using my computer right now, maybe because of the
Okay,
internet
Nadira.
connection.
Okay.
Wait, let me share my screen back. Okay, so may I continue, Tuan Faisal?
Yes, please.
Okay. Sorry for the interruption. So it will be the judge's duty to decide after the prosecution has finished presenting their case whether or not they have managed to establish a prima facie case against the defendant. So it will be the duty of the court to determine either the prosecution managed to establish the prima facie case against the accused person. So if the prosecution managed to
Not
prove such a
against the
case
defendants, against the accused.
against the accused person. Sorry. So if the prosecution managed to prove such a case, the court will ask the accused person to present their case or defend themselves. So if the prosecution failed to prove such case, the court must acquit. So this is the duty of the court to acquit the accused person and clear him from all the charges. So this can be referred, these are one of the principle in apply the maximum evaluation of the evidence when it comes to the prima facie case. By referring to the case of public prosecutor against Muhammad Razi Abu Bakar, which decided in 2006, the court held that if the court, upon a maximum evaluation of the evidence placed before it at the close of the prosecution case, comes to the conclusion that a prima facie case has not been made out, it should acquit the accused. So this is the duty of the court to acquit the accused person. So if, on the other hand, the court, after conducting a maximum evaluation of the evidence, comes to the conclusion that a prima facie case has been made out, it must call for the defense. So, so one of the cases that successfully established a prima facie, where the court outlined these 4 principles to follow the establishment of prima facie case in rape matter, in the case of Ahmad Faizal Ali bin Aulad Ali and others against public prosecutor. In this case, it decided in 2010. So there are 4 important ingredients in order to establish the prima facie case in rape matter. First, there must be sexual intercourse between the accused and victim. Second, such sexual intercourse occurred without victim's will. Third, there was penetration. And fourth, the testimony by the victim must be corroborated. Okay, so for the first ingredient, in order to establish prima facie case in rape matter, there must be sexual intercourse. So this can be referred to the case of A.B. Malik bin Atan against public prosecutor, decided in 2002 in the High Court of Kuala Lumpur, where this case referred pursuant to section 375 of the Penal Code, which mentioned that a man who had sexual intercourse with a woman under any circumstances enumerated therein was said to commit rape. So this can be referred to the explanation under section 375, the circumstances in which considered as a rape. So by looking at the present case at hand, the sexual intercourse can be proven through medical report, in which already presented by Aina Sophia just now, when Nelly, claimed that she felt pain in her genital. So this is similar to the decided case of Ahmad Faizal just now, which outlined the ingredients of prima facie case. The trial judge relied on the medical doctor, where the doctor found several tears in hymen in the victim's vagina. So the second ingredient is the sexual intercourse occurred without victim's will. So this can be referred to the decided case of Kong Hong Lai against public prosecutor, decided in 2010, where in this case, during the trial, there was evidence adduced by the victim that the appellant had sexual intercourse with her on 2 occasions against her consent and will in his house. So the rape was admissible and was adduced as part of res geste because it was relevant to the fact in issue in the amended charges, i.e. whether the transaction of sexual intercourse was against consent and will of the victim, and whether the 2 incidents may be said to form part of the same transaction. So in this case, it shows that there was sexual intercourse occurred against Nelly's will, the victim. That's all from me. We will continue with Hazim.
Thank you, Nadira.
Assalamualaikum warahmatullahi wabarakatuh. Am I audible?
Okay.
Okay. I will
Hazim.
proceed to. I will proceed to the next element, in which the elements of penetration. As we can see in the section 375 of the penal code, it says that the penetration is sufficient to constitute the sexual intercourse. But however, the meaning that has been the term has been given in that section is such in a general meaning. So by referring to the case of pendakwa raya against Muhammad Malik Rizwan, cited in 2014, in which the judge in this case held that the meaning of penetration is the vulva by the penis with or without the emission of semen. Therefore, it is quite possible to commit the offense of rape without producing any injury to the genitals or leaving any seminal stains. And the victim must also identify what happened to her private area actually. So we refer to the case of Ahmad Faizal Ali bin Aulad Ali and others against public prosecutor. So in this case, the victim could identify the male organ was penetrated into her private part as the light was switched coming from outside of the room. So hence, the identification of the penetration can be said to be done precisely. Next. Next slide.
Nazim, please proceed.
Well, next is the other elements that need to be fulfilled by the prosecution in which the testimony given by the victim must be corroborated. So we refer to the case of Sidik Beludan against public prosecutor. So in this case, it was found that there is the evidence of the victim was sufficiently corroborated by the two doctors who had examined the victim and the appellant. So then the medical evidence adduced by the prosecution was sufficient enough to corroborate the evidence of the victim. Also, the evidence of the victim was corroborated by the prosecution witness. So to apply with our present case, so in order to prosecution charge Halim and Ah Chong under section 375, the prosecution must satisfy all elements, which is firstly they must be proof that the sexual intercourse had took place between Nelly and both of the accused, which is Halim and Ah Chong. So based on the given facts, we apply to the case of Abdul Malik bin Atan just now. So it was provided that sexual intercourse did happen. So as for the second element, the prosecution need to prove that the sexual cause will happen without the victim's will. So we refer to case of Kong Hong Lei against public prosecutor. In our present case, sexual intercourse took place while Nelly was drunk, so she was not able to refuse or struggle to be escaped from being harassed. Uh, as for the next element, which is penetration, so the prosecution must prove the accused male organ was penetrated into the victim part. So it based on our present case, so Nelly realized that her private part was in pain. So and there is also the presence of semen that was still sticky around her genitals. So we applied to the case of pendakwa raya against Muhammad Malik Rizwan. So it can be said that element of the penetration could be fulfilled. And last but not least, we apply to the case of Sidik Beludan. As for the testimony given by the victim must be corroborated, in which in this case, uh, uh, Nelly must support her testimony with the medical evidence, also with the witness from the doctor who examined her. So as to be concluded, by having these elements and requirement, we would like to conclude that there is a prima facie in this case. And as for Halim and Nachong, they should be called to be entered into the defense. So that's all from me. I will pass to the next presenter.
Thank you. Zim?
Next, we will be moving on with the question 3. What are the defense that can be raised by Halim and Ahchong? So next. So first, let's take a look at the ingredient of rape under section 375. So there are 3 elements that need to be fulfilled, which is there must be sexual intercourse between the accused and the victim. There must be penetration, and the penetration happen without a consent. So the elements of sexual intercourse and penetration are related to each other, as we can see in the case of Tate and Frazier, where sexual intercourse means actual contact of the sexual organs of a man and a woman, and an actual penetration into the body of the latter. And sexual intercourse are defined in RMA occurs as soon as there is penetration. So next. So in the case of Aparaf Satya against public prosecutor, where the medical report in that case stated that the fresh injury was done by the entry of something, and the doctor in his evidence stated that the complainant had told him that the appellant person only managed to put his finger in the private part, and it was another person who achieved the penetration. So the High Court set aside the conviction and held that the doctor did not provide corroboration of the complainant's evidence that there was entry by a male organ. And in another case of Bunya Nak Jalung against public prosecutor, where the appellant was charged for raping a 14-year-old girl, where the girl gave birth to a baby boy. And when DNA test was done, it shows that the appellant was the father of the baby. However, the appellant alleged that he never had sexual intercourse with the victim, as he only insert freshly ejaculated semen with his finger into the victim's vagina. So his conduct does not fall within the legal definition of rape, which defines rape as penetration by the accused penis into the victim's vagina under certain non-consensual circumstances. The courts allow the appellant to appeal and set aside the sentence. So by referring to these 2 cases, what we could say that the penetration happens must be between a male organ into a female sexual organs. So next.
Bunya Nak Jalung, can you refer to the Bunya Nak Jalung case?
Yes.
This is very interesting case, Farah Nabila.
Yes.
Despite the appellant or the accused being released from the conviction, set aside from the conviction, but there is a baby, was
Yes,
born.
there is baby.
And then from the evidence, it showed that the DNA of that baby is same or similar with the DNA of the accused.
Yes, so the appellant in his testimony said because the victim's vagina was too small, he only insert his finger. And the doctor testify does not reject that the probability of being pregnant by inserting the finger with the semen. So
how come there's a baby boy?
Yes, so because the doctor does not reject that the possibility of being pregnant by inserting a finger with the semen.
By inserting semen using fingers?
Yes, the semen covered the finger, and when it insert into the vagina, the doctor from the
okay. Actually, this team is very good, because I'm planning to ask a question on this matter for this particular team, but fortunately you bring these 2 cases, Okay, very good. So to have a baby does not necessarily using males penis penetrate into women's vagina. Using fingers, using pen, pencil, whatever it is, so long there's a semen, inshallah, by God will, there will be a baby. Okay, never mind. But this is very, very, very interesting case. Yeah, I'm recommending to the whole class to read Bunya Nak Jalong against PP and Apara Satas case. Yeah, this is a very good case. Yeah. Okay, please proceed, Farah Nabila.
Okay, so by applying to the Nelly situations, Nelly only made an assumption that she has been raped based on two reasons. First, there are semen around her thigh and her private part, and second, three of them are naked during she was awake. So this means that Nelly herself does not witness the actual sexual intercourse happen. So even though the medical report evidence had corroborated with Nelly's statement, the medical report shall provide details information regarding whether or not the penetration has happened. So if there are hymen tears, it shall be details the cause, whether it was caused by male genital or could probably have been caused by insertion of blunt or solid objects such as finger and so on. So a mere existence of semen belongs to either Ah Chong or Helmi does not constitute that there are penetration by them. And the prosecution must prove that there have been a penis belong to either Helmi or Ah Chong or both of them had penetrated into Nelly's vagina, then it will fall into rape. So when one of the elements is not fulfilled, thus it will not amount to rape.
Okay, hold on, Farah Nabila. Farah Nabila, can you refer to the sections, to the Penal Code section 376 on rapes? What are the section state about penetration? Okay, your friend in this group, can we refer back to the section on in the Penal Code? Yeah. Please show to the class section 375 and 376. The first presenter. Siapa tadi first presenter tadi? Sofia ke? Siapa tadi?
Saya doktor.
Okay. Saya doktor. Saya bukan doktor.
Saya buat.
Adin. Okay, cuba tengok. Section 376, 375. Rape. Tengok rape. Tiga tujuh lima. Okay. Cuba tengok klausa berkenaan dengan penetration. Okay. What do you understand with this particular provision, explanation? Penetration is sufficient to constitute the sexual intercourse necessary to the offense of rape. Okay. Penetration tu, is it a compulsory? Is it a mandatory must by way of male penis? Open for discussion. Fadila?
So if we refer to previous case of Bunya Nak Jalung, so he did penetrate the victim, but he was using his finger. So the penetration must happen between a male private organ and into the woman's sexual organs.
Have you conducted search on other cases? Research on other cases? Or even latest decision on the definition of penetration? Is it a compulsory? Is it a mandatory? Penetration must by way of male penis only. Anyone from this team? Nabila, you are searching through MLJ atau CLJ?
LexisNexis.
LexisNexis, so MLJ lah. Okay. Okay, never mind. You may continue with your presentation, but for the time being, I hope your other friend, other colleague, make a research, a quick research on the penetration. Whether to constitute rape, penetration must by way of male penis. Please, yeah, Nadira, Nazim, Ahmad Hazim, Sophia, please help your team. I need the answer before we end our session. Okay, Farah, please continue.
So that's all for my points. Afika Azizi will continue the presentation for the defense can be
Okay.
raised.
It is now your duty to make a search.
Okay, thank you, Farah. Am I audible, Tuan Faisal?
Yeah,
Okay,
please.
thank you. Okay, Bismillahirrahmanirrahim. My name is Siti Nur Afika. So next, I'll proceed to the second defense, which is in regards to the authenticity of the CCTV. Okay, so as explained earlier by my colleague Nazim, which we refer to Section 3 of the Evidence Act in explaining where documents are described as any matter embodied in a disc, tape, film, or other device whatsoever. And also, computer is being defined as any device for recording, storing, processing, retrieving, or producing any information. Also, as explained by Nazim earlier, where we refer to Section 62, Explanation 3 of the Evidence Act, where a computer produced document is to be said as primary evidence. Okay, next. Okay, so in regards to the issue where either the CCTV recording is admissible to be presented to the court, the prosecution must first establish as per Section 90A of the Evidence Act 1950, where to tender a certificate signed by a person responsible for the management of the operation of the computer or by way of calling the maker. So we refer to the case of a public prosecutor against Muhammad Abdul Aziz bin Ibrahim, where failure to present either the certificate or the oral evidence would render the CCTV recordings to be inadmissible. Okay, next. Okay, so in regards to the weightage of the document, which in this case, in regards to the CCTV recording, which had been presented to the court, we refer to Section 90BA of the Evidence Act, where in estimating the weight, the court may draw any reasonable inference relating to the document, including on its accuracy. Also, in Section 90BB2 of Evidence Act, the court should regard on possible circumstances whether or not the person concerned with the custody of the document had any incentive either to conceal facts in the document. Okay, next. Okay, so to apply in the case at hand, where the prosecution submits that the CCTV recording as an evidence, since the security guard is responsible for the management of the computer as per Section 90A of the Evidence Act. So in regards to the authenticity of the CCTV recording, the security guard is indeed the person in charge of the CCTV. Thus, in referring to Section 90BA, which I've explained just now, where reasonable inference may be considered by the court as it is likely for the security in altering the recording as if Nelly showing her consent to voluntarily follow Halim and Ah Chong into the hotel room. As we could see based on the facts, there is no sign of any physical force or coercion to happen against Nelly. Also, to the fact that there exists doubt for the CCTV to not have any audio. Thus, Section 90B2 of the Evidence Act applies to show that there may be an incentive for the security guard to conceal on either Nelly had acted orally or physically to prove that she consented to follow both of them, which is Halim and Ah Chong, to the hotel room. Okay, next slide. Okay, so in regards to the failure to prove beyond reasonable doubt, the prosecution had failed to prove that there were no consent by Nelly due to the possibility that the CCTV recording may be tampered. Thus, the requirement of rape in proving that Nelly did not consent to the act will not fulfill. Because logically, the capture of the CCTV recording will only limited to the hallway at the hotel, not to the extent into the hotel room, as for the sake of the customer's privacy. Thus, the element of rape in which there shall be penetration will not be fulfilled unless corroborated by the expert witness. Also, since the incident happened at night, there may be doubt for the security guard to confirm that the two persons are indeed Halim and Ah Chong. So, any failure in proving the above would render the CCTV recording to be inadmissible. Okay, next. Okay, so to conclude, there are two possible defenses that can be raised as explained by my colleague Farah just now, where failure to genuinely prove the act of penetration as to charge both Halim and Ah Chong for rape, and second, to raise a reasonable doubt as to the authenticity of the CCTV recording to be tampered. I guess that is all from our group. Thank you.
Okay. Thank you, Afiqah. So, any of this team define the answer to my queries?
Tuan,
Okay, please, Nazim.
I'm sorry, I cannot find case, but I read a few articles, which is regard of penetration of things beside penis. So in Malaysia currently, rape is to be considered as only to happen if the penis enter the vagina. However, if other objects such as a pencil or a finger is considered to be a sexual assault but not rape, which is under different section, which is section 377 of
Very good,
C.
Nazim. Alhamdulillah, very good. Okay, okay, thank you. Yeah, but the explanation in section 375 about penetration is still open for any evaluation in law. Possibly in future, a legal fraternity or any of the judges make a decision on this point, probably in future, or even our parliament will make an amendment to that particular penetration to make it clear at least. Penetration must by way of male penis, penis only. But for other thing, let's say by pencil, by perfume, by fingers, by food, or by head, or by vegetables, vegetable, that fall under different category of offenses. Okay, thank you, Nazim. Alhamdulillah, you are very good. By the way, I like the presentation of this group and the group before this, except for this particular group, I think a few points on the defense, basically. Defense not only on two aspects, there are other things also. You can raise so many doubts, about not only about the statement from the guard, not only from the CCTV, not only from the Siemens, not only from the expert evidence, expert opinion from the doctors, but also from the victim herself, from the victim. The victim is a GRO, public relation officer. So is there any possibility, let's say, that particular Siemens does not belong to Halim and Ah Chong? Probably that Siemens belong to the customer before Halim and Ah Chong. Okay, so many ambiguous because there's no direct evidence. For example, CCTV inside the hotel room, for example. So never mind. I'm satisfied with the presentation of this group and the group before this. Alhamdulillah, very good. Hope the group after this also make a same or at least same level or better than this group. I'm expect from the law student to be more critical. Don't just copy paste from authority, from the decided case, from the act. You must make your own critical analogy, make by reading from other journal, from other countries' decision, or even by watching movie, movie macam CSI, apa lagi whatever lah investigation punya movie except Bollywood's movie. Bollywood not recommended. Okay. Any question? Any queries or anything you want to add on to ask me, or just any recommendation or comment? Please. We have 2 minutes. Andira, Afiqah, Farah Nabila, Ahmad Nazim, Sofia, Nazim, the guy behind you tu siapa tu? Baju kelabu tu. Gelak je dari tadi. From a different class, Nazim Aziz. Same class.
Hakim, Doctor. Hakim Tuan.
Okay, our class also.
Yes, our class.
Okay. Ahmad Hazim. You? Ada apa?
Tadi tu.
Ada muka you macam muka hakim. Probably one day you'll become a judge, InsyaAllah. Okay. Today's presentation, and before this, and also after this, you learn 2 things. First, you learn on evidence. Second, you learn on the criminal side, criminal. And then, Alhamdulillah, insyaAllah, over the time you will understand, insyaAllah, kalau ada kelas criminal or kelas evidence or problematic question, you know how to answer, during final ke ataupun next semester ke, whatever it is, Okay, kalau dah tak ada apa-apa, let us end our session today, our class today, by reciting surah Wal-Asr and tasbih kafarah. أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم والعصر إن الإنسان لفي خسر إلا الذين آمنوا وعملوا الصالحات وتواصوا بالحق وتواصوا بالصبر سبحانك اللهم وبحمدك أشهد أن لا إله إلا أنت أستغفرك وأتوب إليك. Okay. Assalamualaikum warahmatullahi wabarakatuh. We meet again insyaAllah either by end of this week or next week. Group 4 ready for my question. At any time I will share the question to your group leader. So just be prepared. Probably by end of this week you need to present, or early next week. Depend on my schedule. Okay. Nadira, Zulkifli, okay, boleh tidur. Nafiqah, Azim, Nabila, Sofia Azani. Okay, bye. Assalamualaikum.
Thank you.
Waalaikumsalam. Thank you, Tuan.
Waalaikumsalam. Tuan.
Thank you, Tuan.
Thank you, Tuan.
Thank you, Tuan.
Terima kasih, Tuan.
Okay.
Hakim, jangan end lagi. Sekali je. Awak nak masuk ke sini ke? Agak gambar sekali. Macam mana Farah? Farah. Pizza. Alah. Sekejap.
Hai,
Nak
Daud.
call dia boleh tak?